Testing 1 2. Check 1.
Check, check, 1 2. Check, 1 2. Check, 1 2. Check, 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 1 2. Check, 1 2. Check, 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 1 2 1 2 1 2. Check, 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 1 2.
Testing 1 2 1 2. Check 1. Huh? Check 1. Testing 1 2. Check 1. Check check check. Check 1. Check 1. Check 1. Testing 1 2.
Check, 1 1 1 1 1 1.
Check 1. Check 1. Check 1. Check 1. Testing 1 2. 1 2. Check check. There's this one here. Check one. Testing 1 2. Check check. Check one.
to our viewing audience in Trinidad and Tobago and abroad. Tonight we meet to call for the repeal of the Public Procurement and Disposal of Public Property Bill 2020. This bill amends the Public Procurement and Disposal of Public Property Act number 1 of 2015, which was assented to on the 14th of January 2015. We, in this distinguished panel here this evening, comprising former Senator Sean Sobers, on my left, the financial consultant, the eminent Ved Siriram. We have attorney at law and community activist, from a well-known family in Trinidad and Tobago, Ms. Nafiza Mohammed, and the one and only Dr. Tim Gopi Singh, former Minister of Education. Tonight we call for the full operationalization of Act number 1 of 2015. And why do we say so? Because the original act is stronger, more comprehensive in its remit, and allows for the fullest level of transparency and oversight in the procurement and disposal of all state assets. The Wheaton Bill, which the government passed recently in both houses of parliament, and this was done late last year, removes the following services provided to public bodies or state-controlled enterprises from scrutiny from the Office of Procurement Regulator. And here are the areas that have been excluded: legal services, financial services, accounting and auditing services, medical services, or, and this is the most dangerous one, such other services as the minister may, by order, determine subject to negative resolution by Parliament. The new bill also excludes oversight by the Office of Procurement Regulation for government-to-government arrangements, and also procurement resulting from contracts between the government and international financing institutions. So, critical areas of public procurement have been gutted, not allowing for oversight by the Office of Procurement Regulation. But not only government procurement will be affected, but the disposal of assets. A letter was read to us in Parliament from the procurement regulator, which said, and I quote, "The office," this is the Office of Procurement Regulation, is of the firm view that despite the mandate of the office to dispose of real property, the office should not, I repeat, should not be responsible for direct disposal of any assets, inclusive of real property. So the Prime Minister, could jump on a plane if he gets permission to leave the country, if he gets an exemption by the Minister of National Security. He could jump on a plane and go to Australia and buy 2 boats, just so, under a government-to-government arrangement. And we can't say anything. He can sell the port, the Port of Spain port, if he wishes, under a government-to-government arrangement with little oversight. He could dispose of Petrotrin just so, carte blanche. He could Mama Guy Roger, change the goalposts if he so desires, and all we could do is talk. He could sell NP gas stations to friends, family, and financiers. This government is set to engage in wholesale, boldface, brass-face thievery of state assets. This government's plan is to thief, and sell. That is their plan. It is inconceivable, ladies and gentlemen. There's a rumor that there is a plan to sell everything, thief what remains, and I say this is a rumor, sell everything, thief out what remains, then call a general election and do everything in order to lose, and let the UNC win and inherit a wasteland. Now, this does not make sense, but given the craziness that passes for governance these days, it is not far-fetched. So they go to the general, so they deliberately lose, leave us like they did to Nar with a wasteland, to inherit a wasteland, and then they sit back and plan for the next general election. So I understand that the PNM is already planning for the general election of 2030. That is the rumor. Tonight, we have a star-studded panel to enlighten us more on this issue. And our first speaker tonight will be former Senator Sean Sobers, who is no stranger to our audience. And he will be followed by attorney at law, Miss Nafiza Mohammed, followed by financial consultant, Mr. Ved Siram, and then the one and only Dr. Tim Gopi Singh. Afterwards, we will get questions from the viewing audience, and we will answer them as a panel. Thank you, and I give you former Senator Sean Sobers.
A special good night to all the members of the United National Congress, all persons who may be viewing this particular live stream. Special good night to our panel here, as mentioned by MP Rodney Charles, and a special good night to Mr. Charles himself, the MP for Naparima, for putting together this procurement consultation to call upon the current administration to repeal this particular bill that is before the Parliament, that has passed before the Parliament. And these rounds of repeal consultations that we are having with the public is based upon that call, that mandate given by our political leader, Mrs. Kamla Persad, of Senior Counsel, to do so, because she's recognized that this particular piece of legislation is extremely bad law. Now, the last time that I was on a platform such as this, I was given the opportunity as well to speak about the government's legislative agenda, and that the government's narrative time and time again is to indicate that the UNC does not support the government when they're coming to the Parliament to pass good legislation, that the UNC is unpatriotic, and that the UNC will do everything in its power to cripple this administration, especially when they come to assist the public with respect to passing good law. And I went to task to demonstrate that the UNC on a number of occasions have supported good legislation when it comes to the Parliament. That the UNC's mandate is to treat with good law, assist the government when it comes to passing good legislation. That when the government comes to the House and to the Senate with bad law, which is what they do on a number of occasions, we will offer up amendments. The amendments will be accepted and that legislation will be passed. But what we will not support is truly terrible legislation that is solely designed to assist this particular administration in furthering their nefarious activities, which MP Charles would have touched on, and many of our other speakers will touch on as well too, which have no place in assisting the citizens of Trinidad and Tobago. And they are the ones who will be mostly affected by this legislation. My friends, we've heard time and time again that facts are stubborn things, that you can do what you want in this life, but your history will follow you through. And the history of this procurement legislation is a very, very muddied one, especially in the hands of the People's National Movement. And it goes way back to 2005, when the very first white paper was drafted by the Ministry of Finance, was presented, and a Procurement and Disposal of Public Property Bill 2006 was laid in Parliament, but it was never debated. Fast forward now to 2010, when we had something called the Off Commission of Inquiry. Mrs. Mohammed, attorney at law, will give us some context on that as well. But during that period of 2008, 2009, there was one particular individual, at every opportunity he got, whether it be in the parliament or in the public domain, he would say how displeased he was with UDCOT. He would say how displeased he was with the chairman of UDCOT, Mr. Calder Hart. He would say how displeased he was with the amount of assets, with the amount of money that was running through Mr. Hart's hands. He would say how displeased he was with the fact that the Prime Minister at the point in time, Mr. Patrick Manning, did not have any real control as to what was going on in UDCOT and no real control over its chairman at the point in time. And he would indicate how displeased he was that billions of dollars was passing through this gentleman's hands and that organization's hands, unchecked, unmatched. And he stood up in the parliament and he made all sorts of statements about the occurrences of UDCOT at that point in time. So much was his cry of woe and his tale of woe that a commission of inquiry was convened. And that person today is the Prime Minister of our country, Dr. Keith Christopher Rowley. And the commission of inquiry formalized a report into the construction sector of Trinidad and Tobago, including the practices and methods of UDCOT, and to make recommendations and observations on value for money, high standards of workmanship, free and fair competition, integrity and transparency. And that report produced 91 recommendations. And our Dr. Boydrina Tuwari would have spoken about those recommendations while he was giving his contribution on the Public Procurement and Disposal of Property Bill number 2. And he indicated, so from these recommendations, we see that there were problems in the last administration of the People's National Movement having to do with corruption issues, having to do with value for money issues, and having to do with local content and local participation and inclusion issues. Those were some of the recommendations, those were some of the statements coming out of that inquiry. And it was the People's Partnership Administration in 2010, as soon as we got into office, we ensured that draft legislation was sent to a joint select committee that was saved and continued in 2011 and 2012 concerning public procurement. And at every step of the way, the People's National Movement, under the leadership of the then opposition leader, Dr. Keith Christopher Rowley, the same gentleman who had issues with how UDCOT was operating with no proper procurement, stymied the process of this particular legislation in that joint select committee. And just as before, the People's Partnership, once given a mandate, once making a promise to the people of this country, continued with mass consultation because the Prime Minister at the point in time, Mrs. Kamla Persad Bissessar, understood the importance of this particular piece of legislation. And those consultations that were held with stakeholders were headed by former Senate President, Mr. Timothy Hamel-Smith. He was the chairman of the committee. And its specific purpose of that particular group was to checking on the implementation of the legislation. Fast forward a bit, my friends, now to the current day with respect to the People's National Movement. That draft regulations for the procurement bill that was passed in 2014-2015 have already been completed by the Office of the Procurement Regulator, because that is all that was outstanding to properly operationalize this particular piece of legislation. And those draft regulations were submitted since November 30th, 2017. Again, in September 2019, the Office of the Procurement Regulator has been calling upon this administration, inquiring why haven't these regulations been laid and debated in Parliament? They are ready to do their work. But in true People's National Movement fashion, the the Minister of Finance, they have no time for that. And then like a thief in the night, they bring this new procurement, these amendments rather, to the procurement legislation. Now, MP Charles would have touched on some of the amendments. He spoke on all of them actually. And as a lawyer as well, I would want to just delve a tad bit into some of them. Clause 5 of the amendments seek to amend Section 7.2 of the parent bill, which deals with the fact that there will be no oversight for government-to-government arrangements and no oversight for government to international financial institution arrangements. And MP Charles talked about the fact that examples of these relations would have been situations like the procurement of those hostile boats. Let us not forget an example of a government or financial institution arrangement would have been this construction of houses that was supposed to also take place with the China Gazuba contract and that China Gazuba Corporation. That was a contract that was designed specifically to benefit that particular organization and not the people of this country. And under this incarnation of the procurement legislation, contracts like that will not see the light of day, and operations like that would be able to continue to go forth unchecked. Clause 5 of the bill also seeks to amend Section 7.5, which deals with the exclusion of legal, financial, accounting, and auditing services, medical services. Our esteemed Dr. Tim Gopi Singh, a medical practitioner and former Minister of Education, will also touch on how dangerous that is in light of what we're going through now with this entire vaccine fiasco. And then that catch-all clause, Part E, which treats with any other or such other services as a minister by order may determine. So anything else that the Minister of Finance wakes up on a Monday morning or a Tuesday evening as he rolls out of his nest, he can now say must be placed within this bill that is exempt from proper procurement practices and the office of the procurement regulator. And the last egregious clause, Clause 6, which amends Section 13(1)(o), it deletes the function of the procurement regulator to dispose of state property. We are no stranger or strangers to that aspect of things in this country. We've passed through an administration who has gotten rid of Petrotrin. We've passed through an administration who are now in talks with respect to the port of Port of Spain. And as I would have said in another procurement meeting, if you would have asked any of us in this country if any of those things could become a reality, we would tell you no. Sell Petrotrin? Never. Close down Petrotrin? You're crazy. But it is a reality now. And the sky is the limit with respect to other state assets that can fall prey to this particular clause, this particular amendment. We need to get serious as a nation and call upon this particular administration to act sober, no pun intended, with respect to how they treat with laws when they come to our parliament, because it is the people's parliament, and to really start to take the future of this country to heart with respect to legislation and the handling of Trinidad and Tobago's patrimony. Thank you.
Thank you very much. Let me start off by saying good evening, Sitaram, Assalamu alaikum. I want to thank the Honorable MP, His Excellency Rodney Charles, for asking me to be a part of this very distinguished panel with persons who I've had the privilege to know over the years, more recently with Sean Sobers, and just to continue with the dialogue on the gutting of the public procurement legislation. I want to add some context into this particular piece of legislation, and I am standing here before you having worked for a number of years in the Office of the Attorney General, and therefore I would like to contribute towards some background information. This discussion is taking place on the eve of the Spiritual Baptist Liberation Day, which will be celebrated in our country on Tuesday. And then you have the Easter weekend coming just a few days thereafter. And then it's the time known as Noratram in the Hindu faith. And of course, the holy month of Ramadan is just around the corner for us in 2 weeks' time. So I just want to say that we are blessed in this country. We have such diversity. And before I came here, I was able to hear a bit of the Prime Minister's media conference today. And, you know, we heard about being in this pandemic time and the very limited resources that we have. We are all in this thing together. And we are really and truly, we want to get value for our money. And it is for this reason that this kind of discussion, I think, is so significant at this time in our country in an effort to keep our legislators and whoever in positions of influence focused on being able to promote better governance or good governance in our country, because at the end of the day, good governance is about accountability and transparency. And what we have been witnessing in the last few months, if not the last few years, it has caused me to now take a position that is you know, it explains why I'm here today then. I was also very pleased this evening when I listened to the conference and a reporter asked the Prime Minister a question about the recent video that has probably gone viral. And it was a video with our Honorable Attorney General in a gathering of men, all of whom were flexing their muscles as they were doing some hand wrestling. And our distinguished Attorney General was in the middle of that, no masks and so, but they were all there as men flexing their muscles, powerful men. And you know, I said in this discussion this evening, I want to make a point about the very flawed manner in which our Attorney General has been approaching legislation in this country. And I'm saying this against a background where the Attorney General would have entered the Parliament, I think, probably after the 2010 general elections. And now that he is in that powerful position as Attorney General of this country, I think he and some of his colleagues failed to realize that there were governments before them. And therefore, when they are taking positions to advise the government generally, they need to be exposed a bit more to some of the institutional background. And I say this because my colleague Sean mentioned the genesis of the public procurement legislation with the 2005 white paper and the laying of a bill in the Parliament, I think in 2006. But I want to go even before that, because in 2002, when I returned to the Attorney General's office, I recall being exposed to a list of bills that were left behind by the previous UNC government, and there were more than 150 bills, and amongst them was a bill that was in the embryonic stages being promoted by the then line Minister of Finance. I think it was Gerald Yetming at the time. And it was about regulating the processes with respect of statutory authorities and state corporations and state enterprises. And in 2003, 2004, there was a change of Attorney General. I recall when former AG Glenda Morian became our High Commissioner in England, and John Jeremy came in, and I became part of a team with the then Chief Parliamentary Counsel and another attorney at law. And we visited every single ministry to discuss their legislative agenda. And from those meetings, we were able to come up with an actual legislative agenda, which was laid in the Parliament, I think, in 2004. And it was from those meetings, through the Ministry of Finance, that the policy development for the reform of some of our financial laws, especially the very archaic Central Tenders Board Ordinance of 1961. A lot of work was started, and this white paper came into being in 2005, and a bill was in fact formulated in 2006. And I remember when, for whatever reason, around that time you had the emergence of special purpose companies and the rapid formation of special purpose companies. It started off with CISL, it had Palaseco Development Company, Rudicot. I remember EFCL coming into being, and the NIDCO and others, new entities. It was a period of tremendous reform that was happening. But there was something in the system that was blocking this procurement legislation. And then you had the very tense period after the 2007 elections. And our current Prime Minister, as Sean pointed out, was at the forefront of the charge against Udicot and Mr. Calder Hart and the expenditure of taxpayers' dollars and the mega projects that was being undertaken by Udicot with limited checks and balance. And so you had the off inquiry, so that in 2010, when the government changed, I gather that in terms of what was left in the pipeline, a lot of consultations and collaboration would have taken place. And in 2015, I think it was when that particular bill, the actual public procurement, the procurement and disposal of property bill was actually enacted in 2015. And what has happened since then? There may have been a bit of tinkering with it in 2016, 2017, some small amendments. I gather the regulations were formulated. But then all of a sudden, nothing, of course, has been, was proclaimed or implemented. But like a thief in the night in December of 2020, on the 4th of December, I gather a bill was laid in the Parliament to remove certain parts of the legislation that had been passed in 2015. And within a matter of days, the approach that was taken with that bill is one that is very questionable indeed, because the AG would have stripped that legislation in a way, an act that was enacted with a special majority would have required a special majority. That act was actually gutted with a simple majority bill. And this has been an approach towards lawmaking by the Honorable Attorney General, which I am sure many others have serious concerns about that approach, because just for the sake of getting it through the Parliament, you had this gutting of the bill. And what is even more disturbing is that the Honorable Minister of Finance, by now we're all familiar with his style of operation. We stay quiet, and of course nobody rioting, so he's so experienced, he's able to push the button far and wide. And it's time, I think citizens are recognizing and realizing that enough is enough. Because in his commentary around that time, when in December of 2020, when there was an uproar that was unfolding with respect to the proposed amendment, which Sean just pointed out, with Clause 5 in particular, that would have amended Section 7 of the 2015 Act, and would have removed the oversight over certain areas of activities. You would have had the Minister of Finance at that time making some very, very adverse comments against the media and against the stakeholders, very well-respected persons in the country who would have expressed their points of views. And I saw where, for example, now he made comments about in that particular bill, he talked about the international best practices in respect of public to public procurement arrangements. He said were well established as international best practice. And I wanted to comment on that because I'm in a forum with a very well respected person who comes from the diplomatic service. Because here it is, we are talking about international best practices. And what irks me in all of these comments is the hypocrisy that we are seeing when it comes to governance and some of the issues that are involved. We have had, for example, we are seeing where this amendment to the public procurement legislation would have watered it down considerably. And we have to ask some very significant questions at this time. Not too long ago, we just saw what has happened in Tobago, where there is a virtual deadlock in Tobago. And in terms of governance, God alone knows what is going to happen. We have had years of work, years of resources pumped into an internal self-government piece of legislation. And all of a sudden, an election happened last year. That legislation, the policy towards that legislation was approved by the cabinet, laid in parliament, was before a joint select committee, and the election came and went, and not a word about internal self-government. Now, after the THA elections in January of this year, and with the deadlock, now we are hearing this talk about internal self-government. But one of the issues that is concerning me is the fact that one of the mega projects that was articulated in recent times with respect to Tobago, and mind you, I know they say fowl have no place in cockroach business, but we are all taxpayers of this country, and we have to be concerned. We want good governance at the end of the day. I recall seeing in the public domain in 2018 when residents who have to be relocated for the new airport expansion project in Tobago started to protest, and the Prime Minister at a forum called Conversations with the Prime Minister in 2018 in Scarborough, he actually made certain announcements, and one of the things I recall seeing in the public domain is that the airport was expected to cost $500 million. I understand there was a billboard for a long time in the car park in the existing airport that actually had some drawings that were agreed upon in terms of what this new airport would have been like. All of a sudden in 2019, I think it was around budget time, and thereafter we started to hear that that new airport project is going to cost $1.2 billion. And up until this day, I am yet to hear what is that about. And that contract, in those days we were hearing, it was a contract that the Chinese government would have been pursuing. But now, you know, there's a silence. What really is going on? And without a sudden increase from 500 million to 1.2 billion in these COVID pandemic times, it is a time, yes, everybody recognizes there's need for a new airport in Tobago. But we need to be realistic and to, you know, look at our priorities and try to see how we can cut our cloth, as they say, to suit our faces. So that is one aspect of things that has been of concern to me. And when the Honorable Minister of Finance talks about, he made the point about the public-to-public procurement processes and the fact that these arrangements are well established as international best practice. And he said, he referred to the commentaries on these issues as uninformed and serves only to undermine public confidence. Very strong attacks at persons who have the well-being of the country at heart, and genuinely so. And I asked the question, if you are so concerned about international best practices when it involves money, you know, my father used to say on Mastana Bahar, solid liquid cash. Here you're talking about millions and billions of taxpayers' dollars when you are dealing with these big mega contracts. I want to ask the question, and I want to ask the Attorney General, what about the international best practices as it relates to our humanitarian issues that have now been out there in the public domain, where human rights organizations all around the world have had to make comments about what is happening here in Trinidad and Tobago? I'm sorry for raising these thorny issues in a procurement forum, but they are relevant in terms of the process of lawmaking and the priorities and the manner in which these matters are being dealt with. I recall since 2010, before 2010, so much work was already done, training being done with customs, immigration, police, law enforcement, persons from the AG's office, the National Security Ministry, as it relates to some migration issues, including refugees and asylum seekers. Since 2004, there was an ad hoc procedure developed in collaboration with the Human Rights Unit in the Office of the Attorney General, and I was part of that process. Today, we have an actual migrant crisis, a refugee crisis on our doorsteps in light of what is happening in Venezuela. And what is our position? Where is the legislation? We are required to enact a refugee law in this country. Yes, we have signed and ratified the convention since 1951, 1967 protocol. We have some little provision in the Immigration Act. but the IOM has been here for years. The UNHCR has been here for years. And you see the fiasco that we experienced last week, it was just a continuation of the high-handedness and the attacks that have been made as it relates to our diplomatic relationships with other countries, other governments, more so other agencies, international, highly respected international organizations and NGOs from around the world, far less for right here in Trinidad and Tobago. It really irks me when I hear the kinds of comments being made at the highest level, attacking these organizations that have been working for years in collaboration, whichever party is in government. We all have a stake in the well-being of our country. We are going through some difficult times. It is a pandemic period, and we need to be together on some issues. And instead of always attacking and blaming, I am respectfully asking and pleading with those who have a voice, because plenty of people have gone silent. And I think it's because they are afraid, they have been bullied. I know I have experienced a hell of a lot since I made certain statements last year and I took a stance. And that's why I didn't hesitate to come here tonight. Because our country is on a slippery slope. We are going down rapidly, and we all need to come forward and put a hand to rescue our nation. And so, with these few words, I just want to say, whilst I'm talking about international best practices, we have signed and ratified so many conventions and treaties. We have a crisis on our doorsteps, a humanitarian crisis with the Venezuelan situation, many persons being here seeking asylum and refugee status in our country, and I think the situation is not being handled appropriately. And if you want to say that I'm studying foreigners and migrants, I have also been an advocate. Right now, we continue to have 70 children and 24 women languishing in a refugee camp in Syria. These are our citizens, and I am humbly making a plea to whoever may have a voice and some position of influence wherever, that these are humanitarian issues and they are international best practices that we ought to be observing. And I'm respectfully asking that we do all that we can, because it's lives we're dealing with. It's not just about dollars and cents and millions and billions of dollars. It is about human beings. It's a crisis, and we need to approach these issues in a more meaningful way, a manner with compassion and with that humanitarian spirit. And I just want to wish everyone God's blessings as we approach this very holy and sacred time in our country. Thank you, Mr. Charles, for allowing me.
Mr. Chairman, Honorable Member of Parliament, Mr. Rodney Charles, distinguished panelists, members of the audience, and members of the viewing public, good evening. We are here to talk about the procurement and disposal of public property legislation and the impact of the amendment regarding the management of the public purse and public assets. We are undergoing a very difficult economic times in Trinidad and Tobago, and I'm making this public appeal to the President not to proclaim this bill, for the simple reason it's going to take us into greater debt and further economic peril. And we do not have to wait long to see the results in the event that this bill is proclaimed. No doubt the Act in its original form was a major step in the right direction, where all arms of government and state enterprises would have been subject to a uniform code and rules with regard to the procurement and disposal of public property. In addition, the regulator would have had the responsibility to ensure that best practices were employed, and they would have had the authority to regulate the process and apply penalties where due. The regulators also have the gargantuan task of training the vast number of civil servants and state enterprise employees engaged in the procurement and disposal process, including management and directors. The government, in its wisdom or lack thereof, has introduced many exemptions that render the Act impotent. The disasters of such amendments have been well articulated by the opposition, civil society, the Law Association, and many chambers of commerce. The amendments effectively created two sets of regulators, one being the regulator and the second being the Minister of Finance. This is a recipe for disaster. The exemptions created by the amendments include government-to-government contracts, public-private partnership, finance and banking, accounting, legal, medical, and any such services that the Minister of Finance may determine. Effectively, there was no use for a new regulation act. They should have gone back to the tendering process that served us many years in the decades in the past. I will address the first three, government-to-government contracts. This was not defined in the Act, or even if it was, I certainly missed it, but I looked carefully for it. What exactly does government-to-government mean? Regarding the procurement of the vessels from Australia, what role did the government of Australia play? What did they build the vessels? Was the financing made by the Australian government or through one of its agencies? Was the Australian government party to any agreements that were signed? Was the Australian government acting as a broker putting the deal together? All these questions I did not find an answer for. Was there any precaution done by our government regarding the value for money on the vessels? How was this process conducted? Was there any evaluation on the cost of finance, or was it lost in the package? Were alternative supplies for vessels considered? If not, why not? How did government arrive at the decision for the vessel procurement from Australia? All of these are relevant questions that must be answered. Can our government put their heads on a block to confirm that that was the best deal on the table? Regarding the engagement of many Chinese construction firms, would these contracts be considered government-to-government contracts? If so, why? Why such contracts be exempt from the regulators? And the bottom line is no contract should be exempt for low-level sums, except for low-level sums. So in other words, the whole idea of exempting government-to-government contract should not be included in any exemption and must be under the purview of the regulators. The second point was public-private partnerships. The Act defines this as an agreement between a private company and the government, whereby the private company agrees to provide services or assets for government or public use in exchange for payments or fees. The private company takes the risk of the asset. Example, let's look at some examples, real-life examples. The bill-owned lease transfer, the bolt, as in the case with the Tobago House Assembly. The THA sold a parcel of land at a low price to a private company. The company and THA entered a bolt agreement where the company will construct a building and lease to THA for around 20 years. After 20 years, the building will be transferred back to the THA. The THA will contribute a large sum upfront as an initial lease payment and then thereafter pay a monthly lease payment. The company will maintain the building during the time of the lease. The questions we would have under a private-public partnership, with the exemption, this would not come under the purview of the regulators. So the relevant questions, who would have sweated the cost to taxpayers for such an arrangement? That the cost of the building, what was the cost of the building, and what was the cost of financing? What is the difference if THA had borrowed funds and constructed the building? It's the same except perhaps much more expensive. If public-private partnerships are exempt from the regulator's oversight, then all procurement and disposal of public property transactions can be structured to escape the scrutiny of regulators. For example, the Petrotrin refinery can be leased to a private company of the government's choice for 30 years at a soft price. The contract can include a clause whereby the government can reclaim the refinery at the end of the lease period or have the option to extend the lease. This transaction will escape the scrutiny of the procurement regulators. In such a circumstance where all sorts of innovation can take place, I recommend that we do not include the exclusion of the private public partnership as an exemption. The sale and leaseback arrangement. This is another structure that can be employed. The government can raise financing by selling all or selected assets to a private company to raise financing under a public-private contract. Here, the government will sell an asset such as a building and receive cash up front. At the same time, the government will agree to lease the building for a monthly lease payment for a specified period of time. After the lease period, the property will be transferred back to government for zero payment or for a specified amount. This transaction will also escape the oversight of the regulator. How was the private-public contract originated and concluded with the liquid to diesel plant? What evidence is there that citizens got the best deal? Here again, that particular contract with regards to the sale of the liquid to diesel plant would have escaped the scrutiny of the regulators. And therefore, there will be no transparency and no details available to the public. What will prevent the government to structure most transactions at public-private arrangements so that all sale and procurement escape oversight? In other words, billions of tax dollars of taxpayers' money can be spent without oversight and accountability if we accept those amendments as suggested. With regards to finance and banking, this is an area where the treasury of the central government and the treasuries of large state enterprises have been pillaged for decades. The Ministry of Finance do not have the knowledge nor the experience, nor do the state enterprises have the knowledge and experience to manage large funding transactions. Examples are too numerous. They include government interest rate swap transaction where the government lost 75 million TT dollars on one transaction that was concluded over a phone call. If we had the regulators and knowledgeable regulators, such a transaction would have been avoided. The government yen swap transaction where losses may exceed 1 billion TT dollars. The Trintomar Petrotrin, this was done 20-some years ago. Expensive sinking fund loan costing in excess of 35% per annum when interest rates were below 5%. With regards to our WASA bond financing, where the bank pulled off profits in excess of 300 million on a net financing of 1 billion. That is 30% profit on one deal. Conspiracy between bank and airline to deceive investors by recording artificial profits via loans as a sale and leaseback arrangement. If we had proper regulators that understood finance, all these transactions would have been avoided, saving this country billions of dollars. It was reported that the Attorney General mentioned that the foreign banks would prefer secrecy with regards to bank financing, and that is true. I think he was truthful in his statement. The foreign banks do not want any disclosures of the transactions that they intend to do with government. They thrive on secrecy for the simple reason they are scared of their proposals, their transaction proposals and financing to be investigated by knowledgeable Trinidad and Tobago citizens. The regulator is expected to provide control on proper evaluation of financial bids. A major problem is the elementary methods applied to evaluate financial bids. A system of weighting is inappropriate and can be easily manipulated. What are some of the issues? When should the regulators get involved in any purchases or sale of assets? Say, for example, do they get involved after a commitment has been made to invite bids, or do they get involved before? A very important part of the regulations, of modern regulations, require an appropriateness test. In other words, is it appropriate to sell a particular asset? Is it appropriate to invest in an airport in Tobago at this time? Is it appropriate to invest in a road to Toco? Is it appropriate to invest large sums of money in the San Fernando waterfront project? The question is, appropriateness test. If the regulator gets involved after a decision was made, it is too late. An appropriateness test is extremely important, and whilst I didn't see it or it was not clear in the Act when they get involved, my recommendation is that they should also look at the appropriateness test to determine whether such an investment or sale should be made. So when should the regulator get involved? I didn't get an answer to that, but that has to be addressed. Who will determine what is to be bought and what is to be sold? Who determines the cost-benefit analysis? Who does the feasibility studies? Who prepares the justification paper? Because some investments, such as the hospitals, we may not be justifying that by way of economic justification, but there could be other reasons. But that has to be expressed so that the citizens know that, wait a minute, it makes sense to make that investment. What role the parliament plays in the decision to invest? If we are a true democracy, those major decisions should be taken by parliamentarians who represent the general citizenry. In the case of sale of Petrotrin, at what stage would the regulator get involved? If the decision to sell is not in the country's best interest, what can the regulator do in those circumstances? Where was the justification and feasibility study on the Sandals Tobago project? That, my dear friends, is a case in point to study how not to manage the country. No investment must be made without a feasibility and justification study, and that should be enshrined in law. What about fiduciary duties? Fiduciary duties means a duty to act in the best interest of the party you represent. I skipped a page. Let me go back a bit. I want to warn the population, establishing a regulatory body do not guarantee good governance. We have seen the failures of current regulators. The CLICO crisis was as a result of delinquent central bank activities. They failed to regulate the industry. The SEC failed to restore justice in the FCB IPO scandal. However, establishing the body is a step in the right direction, but do not expect, without that regulatory body being manned by very professional persons, that we will get the results we desire. Can government do what they want? This is the question I pose. The Sedition Act is being challenged as unconstitutional. Can this procurement law also be challenged on the grounds of unconstitutionality? I pose this question to the barrage of attorneys in Trinidad and Tobago. It does not make sense just opposing for opposing state. I've learned from one of the attorney friends who I worked with many years. He said, if there is something wrong, go and find the law that will redress it. The main purpose of government is to establish policies and laws that would be in the service of transparency, equity, and in service of the citizen. That is the main purpose of government. The government also has a fiduciary duty to the citizen. The government has this duty whether they recognize it or not. Fiduciary duties mean a duty to act in the best interest of the party you represent. These duties require government to establish proper policies. These duties, it does not have to be written. The very fact that they are in government and they are in charge of governance, they have to establish proper policies and laws to minimize corruption and minimize wrongdoing. The question we have to ask ourselves, if the law as the regulations as presented and the amendment, does it fulfill these these objectives? If not, then the government will be found in breach of the fiduciary duty. If the laws are inadequate and the government insists on not correcting them, then they may be in breach of their fiduciary duties. The traditional view is that governments do not owe the citizens a fiduciary duty. That's a traditional view. However, in 1984 in Canada, there was a tilt where it was ruled that fiduciary duties do in fact exist on government. This is an area to explore, as well as the constitutionality of the amendments. While signing the document saying that the population is not satisfied, I think there's a lot of work for the lawyers to do to explore the question of constitutionality of these amendments and whether government is in breach of their fiduciary duties. I wish to thank you for your attention.
Good evening to our viewing and listening audience, streaming live here from the UNC headquarters in San Fernando. A member of parliament for Naparima, I'm very happy to have accepted your invitation to join with you and the team of speakers here tonight to address the issue of the recent passage of the amendments to the Public Procurement and Disposal of Public Property Act of 2014, which this PNM government railroaded through the Senate and through the lower house with a simple majority. I want to also say a very special good evening to our United National Congress massive team and our distinguished political leader and leader of the opposition and the executive of the United National Congress and supporters and well-wishers of the party. Earlier on, two of our platform speakers took back this issue of the public procurement and disposal of public property bill to even 2001 for a consideration, and then 2006. But when Mrs. Bissessar became the leader of the opposition, and then in her determination in the 2010 election manifesto, decided that public procurement must be a major issue that she will bring forward in her first 100 days plan as a bill to be laid in Parliament. In fact, if I remember correctly, the Cabinet Note number 1 was, of course, her brainchild of the funding for the Children's Life Fund. And I believe the public procurement and disposal of public property was, I think, the second Cabinet Note. And that bill was laid very urgently as a priority from the then Prime Minister, Mrs. Bissessar, in Parliament in 2010 when we formed government. It went to a joint select committee of Parliament, and I was part of the team, and the team that team elected me as the chairman for 1 year, and then followed by Dr. Tiwari as the subsequent chairman. And in that committee, we had then leader of the opposition, Keith Rowley, and MP Colm Imbert on that joint select committee. Well, from day one, we sort of found that these two were beginning to kick up a storm, and for no apparent reason. They began to ask, what is the policy of the People's Partnership government in terms of this public procurement? And they knew fully well everything was within the construct of the bill, and all the explanations were there. So we had presentations from many presentations from very many interested groups, chambers of commerce, written submissions. We had presentation from a procurement regulator from Jamaica who came particularly to give us an analysis of this whole issue of the procurement regulator and the setting up of a procurement regulation team. We had international agencies support as well. And then we looked at countries around the world which had put out and had made law this procurement the Office of the Procurement Regulator. So we went on and did a tremendous amount of work supported by the parliamentary staff. And for some unexplained reason, which they alone knew, opposition leader Keith Rowley and Colm Imbert decided to stay away from that Joint Select Committee of Parliament. And they stayed away for almost 2 years. So when citizens ask, well, why we took so long as a People's Partnership government to complete the bill during our term, it is because opposition leader then Keith Rowley and Colm Imbert did not want to have this public procurement and disposal of public property bill passed. And they had within their minds a hidden agenda. So for 2 years, they did not come to the meeting, and we had to cease the meetings until the interested parties nationally, the Chambers of Commerce, the Joint Consultative Committee on Construction, and so on, began to hammer them as to the absence from this committee. And they had to come back kicking and screaming, not wanting to be part of it, but eventually settled down. And we were able to get the work completed by 2014. And this was laid in Parliament and debated and passed with a majority vote, not a simple majority. This public procurement and disposal of public property bill, which became an act, was passed by a majority of vote. A special majority, not a simple majority. And that was the responsibility of then the Prime Minister at that time ensured that it was passed by a special majority. Since then, there were 1 or 2 smaller amendments that were made to this bill and were passed by a simple majority. And the Attorney General came back again with these amendments and moved to try and pass this with a simple majority again, these amendments that were brought under the new amendments bill of 2020. So it went to the Senate first, and the senators abstained, the independent senators abstained. And it was only one senator, that independent senator, that gave the PNM government the vote that they wanted to pass this bill in the Senate. Well, of course, they have the majority in the lower house, and they said it needed to be passed by a simple majority. The United National Congress opposition said that this is not right, it is unconstitutional, it should be passed with a special majority. But that is the nature of the PNM. Bills that needed special majority all along, as Attorney Sean Sobers spoke about earlier, were passed with simple majority and railroading the Parliament. But obviously at some time, some of these issues will become unconstitutional when brought to court. I want to take you back to post-independence. 58 years ago, 1962 to now, this is the 59th year. And from since that time, the days of Prime Minister Dr. Williams, the country witnessed scandal upon scandal in terms of procurement and management of certain contracts. And in the 60s, you will remember, for the young ones who are not familiar with the history of the past, will remember the Lockjoint scandal. Then it was the John O'Halloran and Francis Privat scandal, and both gentlemen had to go to Panama where there was no reciprocity in terms of the ability of Trinidad government to bring them back to be tried. I think one passed away in Panama itself. Then there was the Tesoro scandal. Then there was the DC-9 scandal. Then was the Caroni Racing Complex, all under People's National Movement. Then it was the Soditech scandal, which is the Mount Hope Medical Complex now. That was given in 1981. It was supposed to cost $500 million. It cost over $1.2 billion when completed in 1986-87. Then you had the Twin Towers scandal, where the cost overrun was massive. And the Court of Justice, now the Court of Justice building, with massive cost overrun as well. And all of these, and even during Mr. Manning's time, Prime Minister Manning, you had the Napa and Sapa massive cost overrun, the waterfront project, which was supposed to cost $2 billion, cost $4 billion in the end, and so many other projects under Mr. Manning's administration with widespread cost overruns, unaccountable cost overruns, and allegations of widespread corruption. So I gave you this information to show that most of these things happened during the 42 years of PNM's administration of governance out of the 58 years for Trinidad and Tobago. So the country was screaming and calling for procurement regulation and calling for some degree of ability to look at what was going on in terms of projects and cost overruns, etc. So the Joint Consultative Committee on Construction and so on, special interest groups, began to feel a little more comforted when this bill was passed in December 2014 and made into act and proclaimed in July 2015. And that act sought to protect and promote the principle of accountability, integrity, transparency, and value for money, efficiency, fairness, equity, and public confidence, and local industry development, sustainable procurement, and sustainable development in public procurement and the disposal of public property. These were the founding principles of that Public Procurement Act. We demitted office in 2015, September 2015. And for the following 5 years, between 2015 to even today, in 2021, this Prime Minister Rowley-led government, together with the Finance Minister Imbert, there has been absolutely no attempt whatsoever to operationalize this legislation, despite repeated and powerful calls from the leader of the opposition, the chambers of commerce, the business sector, the various interest groups, all waiting for the operationalization of this bill, which was passed in 2014. But they have refused to even complete the regulations. They refused to deal anything further with it, except to bring recently these amendments. And why has this government decided to amend Section 7 of the Public Procurement and Disposal of Public Property Act to remove the following services? As my colleagues earlier said, the legal services, financial, accounting, auditing, and medical services. And this amendment bill was debated fiercely in the Senate and in the Lower House, with strong objections from the opposition leader and the opposition. And these amendments were in fact stated and in fact mentioned on several occasions by all to remove the teeth and the gut and sclerose and emasculate and weaken the law, leaving it without any power and rendering it powerless. And in fact, that was the third attempt by the government to water down the procurement legislation. And as I mentioned, they failed to bring about the regulations, complete the regulations. So when Mrs. Bissessa's opposition leader called on Prime Minister Rowley to explain why the government has decided to amend Section 7, which is Clause 5, or subsection 2 of the Act, there is no answer to it. They cannot explain it, why they want to do that. But they know to themselves their nefarious thinking and the nefarious activity that they were engaging in and will continue to engage in. Let me just take, for example, the legal aspect. Many of our citizens today may not remember when before 2010, there was a select group of attorneys that were selected by the PNM to represent the PNM government in matters involving the state and were families of sitting ministers of government and friends of sitting ministers of government. So why do they now want to come and remove this, the legal aspect, from the procurement regulator? Because they possibly have within their thinking that they want to repeat the same aspects of what preceded before 2010, before the People's Partnership government came into office. It's well known, and the researchers could go back and find which families of which ministers and which friends were repeatedly given legal contracts. So they want to give out the contracts and nobody must ask any question. Give out briefs to the legal personnel. Then financial. Why do you want to remove the financial aspect of these from this bill when at particularly this time when the country has emerged in the depths of massive borrowing from the People's National Movement government and the Rowley government? In fact, I want to congratulate the Member of Parliament for Oropoch West yesterday and the entire United National Congress team, which spoke and supported his call for the resignation of the no confidence motion on the Minister of Finance. He was able to present factual information on the fall in the GDP, and then his colleagues and a number of areas within the financial aspects, and was a tremendous, with tremendous statements made in Parliament yesterday by the United National Congress opposition, indicating the failure of the Minister of Finance and the Rowley-led administration to deal with the financial situation in this country. From my analysis, I know they have borrowed almost $40 billion in the 5-year period. And just before we ended the 11th Parliament, they passed by a simple majority to get another $20 billion for borrowing. And we all know what they have done to the HSF and where they have gone. So it's more than $60 billion. Trinidad and Tobago now owe over $123 billion. And the debt to GDP has gone beyond the 80% and moving to 100%, where the IMF usually steps in into other countries. But why do they want to remove that financial aspect of the procurement regulator? They have sinister motives. The accounting principles as well, the accounting aspect. And auditing. Why do they want to remove auditing? Is it because they want to remove the Auditor General and don't have any matters going to the procurement regulator from auditing of state enterprises and government agencies? The Auditor General had picked up that Tobago House of Assembly had an audit for about 10 years, and billions of dollars were spent by the THA, and there was no audit. And a number of agencies and state enterprises under the People's National Movement Administration have not been audited for years. So they want to hide something by removing the auditing function from the procurement regulator. And medical, why do they want to remove the medical aspects of contracts and so on from the procurement regulator? Trinidad and Tobago buys approximately $500 to $600 million in pharmaceuticals and medical supplies on an annual basis. Why do they want to remove that? Shouldn't the state and the regional health authorities be held accountable of the expenditure and the purchase of these medical supplies and medical pharmaceuticals? Do they have intention to give it to a particular firm or an agency which deals with almost all of the procurement of medical supplies for the country? Do they have intentions for doing that? Why do they want to hide that? And why do they want the procurement regulator not to be investigating these matters? And when the whole aspect of the vaccine issue and the procurement of vaccine from the COVAX and the African Council for bringing vaccines into Trinidad and Tobago, when that aspect has almost been completed, we will find that there are hundreds of thousands of citizens who still have to be vaccinated. And then that comes in the question, which enterprise or which company would they facilitate in bringing in the rest of the vaccines to vaccinate the population, to at least consider the question of herd immunity? Is there an ulterior motive in that? And I warn the country to look at that very carefully. Today we saw the Prime Minister speaking about getting 33,000 vaccines from the COVAX group, hopefully by next Tuesday. We welcome that. And we hope that we will get the 40,000 from India pretty shortly. And we're in expectation of receiving some from the African Council support system. But we don't know when. We don't know how much money has paid to that time, to that system from the CARICOM perspective, how much Trinidad has paid. One time the Prime Minister said we're going to get almost 400,000 vaccines from that African support system. We haven't heard anything about that. At one time we heard that we were going to get 100,000 from COVAX. We're now hearing we're getting 33,000. So when will this end? When will this uncertainty end? And then at that time, when you cannot get any more from these and the vaccines go on a commercial scale, who will be applying or who will be bringing in these vaccines? So is there a nefarious reason for removing these legal, financial, accounting, auditing, and medical aspects from the procurement regulator? So I'm coming close to completing my discussion on this. My understanding that it is the opposition's leader's intention to file a bill in Parliament to repeal these amendments. And that is most honorable, because all citizens of Trinidad and Tobago are saying this must not be accepted and this must be debated again and removed from an act and removed as an amendment to the act. But whether we will see it on the order paper for debate is another question. And Imbert is now saying that the arguments against the Public Procurement Act are not based on facts, logic, or international best practice. What facts is he saying that our arguments are not based on facts? The facts are, for too long, this country, under 42 years of PNM administration, has had questions asked almost on the expenditure. Do you know that the expenditure now for Trinidad since independence is close to $1 trillion or a little more? It's about $1,000 billion that has been spent in this country. 42 years of PNM administration, with questions abound, and I mentioned some of the scandals of the past, prime ministers, Dr. Williams, Prime Minister Chambers, Prime Minister Patrick Manning, and I enumerated some of them. So questions have been asked, 42 years of PNM administration, and that must not continue. So the Office of the Procurement Regulator must come into effect very quickly. Questions are being asked now, and mentioned by some of my colleagues on the platform earlier, about what is going to happen to Petrotrin, disposal of public property. Who are they going to give it to? Their friends and families of sitting ministers, companies that are closely affiliated with the present government. So this is just one area. And mentioned also the port. What are they going to do about WASA? What are they going to do about TNTech? These are questions that have come up within recent time. So this Rowley-led government clearly have an agenda. They clearly have a deliberate agenda to deny the citizens their right to proper procurement legislation and for the benefits to the citizens from stemming the misappropriation of public funds. And you would have thought at this critical time and perilous economic time of a global pandemic and global uncertainty, and when they keep on shouting the country has no money, despite their mega projects which they have wasted, they would have rushed to operationalize the procurement legislation. But instead, they have continued to water it down to suit their own nefarious political agenda. And my friends, you must always look at what PNM don't do or refuse to do, not what they say. And so their agenda will come out fully as we move on. And I know the opposition and various interest groups of Trinidad and Tobago, including the business community and the chambers of commerce and the joint consultative committees and so on in construction, will continuously address this situation, and hopefully that this amendment bill, which they passed recently by a simple majority, will be erased from the law books of Trinidad and Tobago. Thank you very much.
Well, thank you very much to this distinguished panel. We have had one or two questions from the viewing audience. Perhaps we could go through one or two in the time remaining. One of the questions is, what can citizens do to stop this piece of legislation from becoming law? Is there any of the lawyers would wish to? What can citizens do to stop this from becoming law at this time? We note
as I see it, the legislation was passed some time ago in the Parliament, but it has not yet been proclaimed. And therefore, in those circumstances, it is only by the public being made aware of its implications and a continuous and persistent call for it to be treated in such a way that it can be repealed. And what we are doing here tonight is making information available to be able to show the public what is exactly the implications of this particular piece of legislation and its ramifications. And we saw what happened a few weeks ago when our country went through a revolution. There was a spontaneous uprising in the nooks and crannies of this country. And very peacefully people have come out and been expressing themselves. And I think as citizens of this country, we are sensible enough to know that enough is enough, and therefore we will get support, I am sure, for that call to be made to repeal that particular piece of legislation, but it is for those in Parliament to deal with it. And of course, from a legal point of view, whatever it is, I hear the call, and I've noted quite on several occasions comments about taking these matters to the court. That we know that takes time, but at the end of the day, these are the options. And the motion by the leader of the opposition.
Thank you very much.
In addition to that, Ms. Mohammed MP Charles, I know that the political leader, Mrs. Prasad Visesa, has made a call for all persons within the party to sign a petition that has been going out, is available at all MPs' offices. I think it's also available. Different persons are popping up with the petitions being readily available for persons to sign. And that will be demonstrative of the public's call, its outcry, its disgust for the gutting of the procurement legislation as it is. So we would want to call upon all persons within society, try your best as quickly and as soon as possible to find that petition wherever it may be. I know that it is, as Mrs. Mohammed said, in every nook and cranny in this country, we've got that petition out there. Persons need to get involved and get active, sign the petition, so that when that bill is laid by our political leader, it can accompany that petition with over 100, 200,000 signatures calling upon this administration to finally do the right thing.
Thank you, former Senator. And probably this is a call to the constituents of Naparima. I think we have already signed, 1,800 of us have signed the petition. Perhaps we should, we should try to make that significantly larger. So we call on the citizens to join with the political leader in showing your support and showing your utter disgust for the legislation. And a question, yes, you can.
I think the question of petition is very important, but I don't see why an individual cannot write to the president and, quite frankly, instruct her, because she is our servant, not to proclaim this bill and give the reasons why. If you're not bold in this country, you're not going to get anywhere. If you're going to be timid, then you deserve to be treated as a tertiary citizen. Secondly, I would like the attorneys among us to see whether the simple passing that amendment by way of a simple majority is in fact legal or illegal. They need to give us an opinion on it. Surely they don't have to be 100% exact, but if there's a cause for bringing a case against the government, that ought to be done. The third point I wish to emphasize is that in my view, there's a serious breach of fiduciary duty by adding in these amendments to the Act. And that also, there's a legal issue involved, and the attorney should come up with an opinion whether there is, in fact, a breach of fiduciary duty. And therefore, if it is such a case, they can have the Act revoked.
Thank you very much. Perhaps we'll take one more question, given the time that we are at this moment. And the question is, how will the country suffer when this law comes into effect? If you could give examples of how this country will suffer if when this law comes into effect?
It's quite evident of what has happened in the past and why this public procurement bill was brought by the People's Partnership Government under Mrs. Bissessa to stem the tide of widespread corruption which preceded 2010 under 42 years of P&M administration. And then for this P&M administration to stop them from continuing that while spending unaccountable spending and without any type of accountability and transparency, as we see already with the hostile vessels, and to come probably the Petrotrin issue, the port issue, and so on. So this is important so that the procurement regulator could have the ability to go into the issues in terms of any procurement area and analyze it within a short period of time and determine the soundness of such practices. And so it is to save the people's money, the hard-earned taxes. And don't forget the last P&M administration between 2015 and 2020 spent almost $300 billion. And what have they got to show for it? With lack of transparency and accountability in their spending of $300 billion. So it is to stop this wasteful expenditure of hard-earned people's money and the taxes that have been paid.
Thank you very much. And this must be the last question. Given the public outrage and that of civil society, we had the various chambers of commerce, the Joint Consultative Council, we had the AmCham, etc. Why is the government, in spite of all this outrage, why is the government hell-bent on weakening the original legislation? There must be concern and must be a thinking and responding to this. Why are they not? Any answers?
Can I?
Yes, you can.
You know, it is a style in governance now that, sorry, something is happening that, yes. I have noticed an increasing tendency to silence anyone who dare to comment or criticize on any issue. Today we heard about the very severe pandemic situation that we are in, where, and all the more reason, we are in a time when we have to look for value for money. And when I heard Ved spoke just now about the appropriate tests that could be implemented, I was quite taken with that, because we have been hearing talks of all these mega projects. We know of the expenditure or proposed expenditures involving millions and billions of dollars. And I think given the Gova seasons that we are in, forget the politics now. Let us all as a nation come together and try and see how we can revisit some of these mega projects and look closely and see how we can get that value for money with accountability and transparency. And hence the reason why the repeal of this particular 2020 legislation, the amendment to the Procurement Act of 2015, we need to deal with it in a significant way now more than ever, because we have too much at stake. We have heard about the extent of our debts, and we want to have good governance. We want to bring back and restore the principles of good governance, which involve accountability and transparency. And therefore, unless you have cocoa in the sun, why are you running from it? And why are you hiding? I have worked with these men who are holding those offices, and I am terribly disappointed with what I see passing out as government now. And regardless of which party is in government, our country needs to put these systems in place. And that is why there is an official opposition in the parliament that is supposed to be the check and balance in our democracy, and hence the reason why I have found it fit to come here tonight to participate in this conversation, because we need people to take a stance and stand up to restore the democracy in our country and to ensure that this silencing and this bullying and the attempts that are made persistently to ridicule and attack people who are trying to make a contribution in the interest of good governance, that, you know, we bring that on and then all come together to help to rebuild and restore this country. It's a rescue mission that is needed, in my respectful view.
At this stage, I think we have come to the end of tonight's proceedings. I would like to thank Senator Sobers, former Senator Sean Sobers, financial consultant. It was it's a lot of information, and a lot of information that we do not normally hear in a discussion such as this. It was enlightening, and we thank you, Mr. Ved Siriram. Well, the distinguished and vocal, Nafiza Mohammed. I think you would do your father proud for what you have, and he clearly, we can see someone standing up for integrity and transparency. And of course, the great, the one and only, Dr. Tim Gopi Singh. All of us today would like to join with our political leader and join with the UNC family to state we must repeal this piece of legislation. It goes against all the tenets of good governance and good government. We stand with our leader in calling for the population to repeal this bit of legislation that is unnecessary and removes transparency and good governance from our collective well-being. I thank you and good night.